reforms will be revisited. I think you said in 2001 several of these old laws were discarded, right? So how many were discarded then, and what makes you hopeful today?
On the old laws part of it, please do realize that the simple part of it is only the tip. What do I mean by the simple part of it? Simple part is when you can identify an entire piece of legislation as redundant. Rare is the case when an entire statute will be readily identifiable as redundant. If the entire statute can be identified as redundant, you can simply repeat it. What was done in 2001 I think it was, is about 200 statutes were identified where all the statutes, the entire body of the statute could be repealed at one go. Unfortunately, that's only the tip. For most pieces of legislation, you have dysfunctional sections. There it becomes even more difficult because you have to sit down. You cannot repeal the entire statute. You have to identify which sections need repeal. In addition, sometimes when you repeal, you also need to figure out whether after you have repealed this, you need a new piece of legislation. That's where it becomes much more complicated.
So you told us that you started your research after 2001. So if you were asked by the government to recommend some changes that could be made fast, next 100 days, would you be able to suggest what could be done?
You see, look...
you didn't tell us why you're hopeful now.
Oh, the reason I'm hopeful now is very simple. Several reasons actually, they all come together. Reason number one is the movement towards law reform. It had sort of intensified under the NDA government, the earlier NDA government. So that's reason number one. Reason number two is it is part of the BJP's manifesto. And reason number three is the Prime Minister, much before he became the Prime Minister, across all of his speeches, he has been talking about it in his speeches, and he has mentioned it, and there are several instances where some changes have been done in the state of Gujarat. Unlike in the last 10 years, at least people are talking about it. That's the reason I said I'm a bit more
optimistic. Bibek Debroy, we are just running this organization Forum for Fast Justice. There are hundreds of antiquated law, as you said. Have you made any efforts with the administration, with the government, with the law ministry, etc., identified laws? Because I will give you one instance. There was one Mr. Achelya, Principal Secretary of Law State of Maharashtra. I was sitting with him last year. He said we have 325 state laws. Out of 100 laws are such which have never been used. So, have you identified, or some sources have identified which are the redundant laws, and have you put it before the government for repealing or amending to the tune of the present time?
The Central Law Reforms Project was, as was said in the introduction, I think I also mentioned it, it was done for the government, except it was done for the union government. You asked me whether any similar exercise, and your specific question was about old laws, whether any similar exercise has been done for identifying old laws at the level of the state. And I repeat what I said earlier, that one of the problems with doing an exercise like this is you have to get a complete exhaustive list of all the laws in the state. And all the laws in all the states are not readily available. Even when they are available, sometimes they are available in the vernacular and not necessarily in whatever the language the researcher wants to do the exercise in. To the best of my understanding, and I may be wrong, to the best of my understanding, there are only 2 states where a specific exercise has been done to identify old state level laws. And these 2 states where it has been done are Rajasthan and Tamil Nadu. Madhya Pradesh has just started that exercise, but it has not been completed. It has been started. So those are the only 2 states where I know that this task of identification has been done.
I have studied one books, Law is an S. I just want to mention one point. I have studied also in the Bombay High Court, and recently now I have read the one book, 7-number column, which is lawyer, from Harish Salvi to Abhishek Malusundri. They are taking charges 25 lakhs. I have not seen not a single advocate, leading advocate, they are taking by check payment. Mostly a check payment, they are mostly taking in cash. I have came across one income tax IRS officer, commissioner. He told me, anyone have got a litigation problem, the leading advocate, he demanded me in the cash. He told me I want to pay in cash, check. But no advocate, leading advocate, I know, they are not taking any cash, but they are pointing to the others people, you can take the cash. So my point, why the leading advocate taking in cash instead of or in lieu of check? So it is must be a point of the legal reform also. You must have to take the check payment.
Well, why Mr. Salve is not accepting payment in check is a question that you can only ask him. I cannot answer on his behalf. But let me answer the question for what it stands. The Payment of Wages Act, which I actually mentioned in passing earlier, mandates payment in cash. Says that payments, wage payments, which is not Harish Salve, but wage payments must be in cash. Why do people accept payments in cash? We are now moving away from law into economics. It is either for tax evasion purposes, or it is instances where the payments are illegitimate. So if you want to address either of those, if you want to reduce payments in cash, one needs to address either of those 2 reasons, typically both. So that would sort of go off too much on a tangent.
Excuse me. Bibek, what's the process to repeal a law? What are the steps? Let's say you find a statute which is you want to repeal. What's the government process for a central law?
For a simple law, you're not talking about the Constitution. For a simple law, it depends on where the statute was enacted. If it is a statute that was enacted by the union government, it has a bearing on the 7th schedule. If it is a statute that was enacted by Parliament from the union list, Parliament just repeals it, full stop. If it is on a state list, the state legislature repeals it, full stop. If it is on the concurrent list and it's a central piece of statute, then if it is a central statute, not a state one, if it's a state one, state legislature. If it's a central statute, then 2/3 of the states have to ask for the repeal. So it's not a very complicated process.
You have not touched in your speech a backbone of our law, that is Constitution of India. Now Constitution of India, if you just say I can point out there are several flaws, and nobody thought, no administrator or legislator of our center have thought of repealing it or modifying it. Just to give you one example, in part 21, Article 369 should have gone long ago in 1955, because it says that whatever the content should last only for 5 years. And Article 370, on which national dispute is going on, that 370 is no longer applicable because it is a transition phase when that Kashmir has acceded to India, and it's that Maharaja's parliament that was existing, and it is no more now, that therefore it should go. And in that case, that something in 371, that is, there are in 371 A to I, that is special provision for the state which can be made for Kashmir also. Please speak, sir.
Well, I follow a simple principle, which is the longer the question, the shorter my answer, and the shorter the question, the longer my answer. And if it is a comment, I don't really need to answer. So far as the Constitution is concerned, I will make only 2 points without getting into the details of articles. First is, the Constitution in 1950 was not exactly the Constitution that we have now. And in many ways, I feel more comfortable with the 1950 Constitution than with the Constitution we have now. Secondly, so far as reforming the Constitution is concerned, there was actually a committee that was set up to examine reforms in the Constitution. That was again during the NDA period. So that report exists. That does not mean I agree 100% with what that committee said, but that report chaired by Justice Venkatachalaya does exist. So there was such a committee.
Well, you have spoken about the laws, the outdated laws, but I have a simple question on simplifying the laws. Let us look at something as basic as a nomination process for an investor. For the shares that you own, you have a separate nomination process. For insurance policy, you have a different nomination process. Don't you think we are burdening the common man by having such kind of complications which can be taken care of by modifying the laws and, you know, making things simpler for the common man and the investor in the country?
Again, let me respond to your question, because many of these questions that concern law reform, they involve several different elements and strands. There was an initiative that was started in Britain under the Tony Blair government, and it was a very, very good initiative, which was to do, before any particular statute was enacted, to do a cost-benefit analysis of that statute. Meaning, what do I gain from enacting this statute? And what do I lose by not enacting this statute? And I don't mean just straight administrative costs of the additional demands on the judicial mechanism. The reason this is important is because of something that I have not mentioned earlier, I should mention now, which is that there is a discipline globally which has not exactly, particularly in the US, which has not really flourished in India, which is the law and economics discipline. And the reason I'm mentioning this now is the way a lawyer looks at law is somewhat different from the way an economist looks at law. A lawyer's approach to law tends to be much more static in this sense. If we have a contract and you indulge in breach of contract, the lawyer's approach or even the judge's approach will typically be, how can I be compensated for the harm that has been caused to me? That's typically the way a lawyer or a judge looks at it. The economist looks at it from the perspective not of remedying the wrong that has been done, but to prevent this in the future. So from an economist angle, the efficiency angle, it is more in terms of deterrence against such things in the future. To address your question directly, there are many pieces of legislation that have been enacted even post 1991, and I will come directly to your question, which have been enacted in isolation. Let me just do this. And the normal reaction of most MPs and MLAs is, whenever I have a problem, even if the root cause is economic, I must solve it through legislation, regardless of whether that legislation can be enforced or cannot be enforced. Consequently, the highest court in the land, the Supreme Court of India, because of the problems with the indirect tax system, has down the years adjudicated whether turmeric is a vegetable, whether garlic is a vegetable, whether coconut is a vegetable, and the coconut instance actually led to a split decision in the Supreme Court. So the point I'm making is, whenever we have a piece of legislation, we need to take stock of what are the costs and the benefits of this law, and also take stock of what are the existing laws which impinge on it and which thereby affect it. But the fundamental response to your question is, we have set up a whole lot of regulators. And the regulators that we have set up differ widely in powers, widely in scope. Had we taken a comprehensive view of what the nature of regulation ought to be, we would have had a much more streamlined template.
In relation to the huge number of backlog, is it not the cause can be traced to two things which perhaps are low-hanging fruit, according to me, and maybe not many people agree, is the way the legal proceedings go, where there are unlimited adjournments or unlimited time given to one party in terms of filing of whatever filings need to be done. The lawyer doesn't turn up, and can that not be more time bound? That is number one, in terms of delivery of justice. That's number one. The number two, I mean, an extension of that is putting a limit on the appeals. As you mentioned, that large number of them involve government or government agencies themselves appealing and putting probably many people, including companies, in harassment. Probably, if these two things are addressed, can the backlog not be cleared much faster? The other, of course, is very low productivity of the courts in terms of delivering of the justice.
Did you mean on the civil side or criminal side, or both?
Both.
Okay, so let me answer this question at some length. Firstly, on the civil side, I mentioned the improvements in the Civil Procedure Code. The Civil Procedure Code now actually says all evidence must be written. All evidence must be written. It's a different matter that judges, particularly when they are browbeaten by lawyers, and there is a broader issue of the judiciary having become captive to the bar. At least on paper, the Civil Procedure Code now says exactly what you're saying. And adjournments cannot be granted. Even earlier, adjournments could not be granted without the judge giving instructions in writing about why the adjournment was granted. But the broader point that you're making, I do buy, about judges not sticking to the powers that they themselves have under the law today. The second part concerns the appeals. 2 points about the appeals. The first point is, in the governmental system today, 3 points about appeals. Firstly, in the governmental system today, a decision to appeal is taken at the level of the section officer. A decision not to appeal is taken at the level of the secretary. If you just reversed it, probably a lot of things would change. If you just reverse the system. However, let me mention something. So far I have deliberately been trying to avoid citing chapter and verse from law. Now, because you asked me the question, I have to do that. There is a Prevention of Corruption Act, 1988. The Prevention of Corruption Act, despite what the title of the law says, does not use the word corruption anywhere else in that statute. Instead, it uses the word criminal misconduct. Criminal misconduct, normally you think, is about my accepting a bribe, about my indulging in nepotism. All of that is criminal misconduct. But there is one particular section of the Prevention of Corruption Act, 13D32, which says, as a public servant, if I take a decision and that decision benefits a third party, I am guilty of criminal misconduct unless I can prove that that decision to the third party was in the national interest. Let me repeat that. As a public servant, I take a decision and that decision benefits a third party. I am guilty of criminal misconduct unless I can prove that that benefit to the third party was in the public interest. The moment I decide not to appeal, this particular section of the Prevention of Corruption Act will be unleashed on me, because it will automatically benefit the third party. The next response I have is, in the year 1996, a decision was taken by the NDC that whenever, not the NDC, initially a conference of state law ministers, and then it was ratified by NDC, which said, if two government entities are litigants on both sides, they will not resort to the court system, but will resolve it elsewhere. Unfortunately, this decision has not been implemented. I should quickly mention the Arbitration Act of 1996. I should have mentioned alternative methods of dispute resolution also. ADR has worked in some ways, at least the arbitration part of it has, conciliation, mediation has not worked that much. Let me now quickly move on to the criminal part of it. On the criminal part of it, I am only going to say the following. The word crime is defined with respect to a piece of law. So when I use the word crime, in general I am talking about the Indian Penal Code, but I may also be talking about what are called special and local laws. About half the crimes in India are under IPC, about half the crimes in India are under SLL. One of the questions to ask is, are many economic transgressions, should they be crimes, or should they be subjected to civilian remedies? Particularly in the area of special and local laws, many of these laws probably do not deserve to be crimes at all. I have answered at length because your question actually is a very long question.
In your opinion, which law should be changed as a priority in India at this point?
Why do I have to pick and choose? If you are going to hold a gun at my head and force me to pick and choose, I will say, if I have to pick and choose, I would pick the Constitution, because it is the bedrock of all legislation. But changing the Constitution is not very easy.
Sir, now that you mentioned about the mess in the Indian legal system, the reformation can only take place from our legislatures. And we know that how our legislature functions, how much time do they give? They hardly function. Most of the time they are adjourned. So personally, how much time should how do you feel, how much time the parliament should function to clean this entire mess, by amending, repealing, or whatever is required?
Look, in the parliamentary, there are all kinds of reasons for dissatisfaction with the parliamentary system and the way it is functioning. It is absolutely correct. What you're saying is absolutely correct, that the average MP is often not interested in legislation. But the more fundamental question is, in a very strange kind of way, the standing committee system has undermined the interest of the average MP in legislation. As an average MP, I think if the standing committee has gone into it, and I've got the standing committee report, why should I bother? Unless there's a party win. The broad point that you're making is fine, and there have been any number of suggestions and recommendations, including saying that one particular day or 2 particular days of the week shall only be devoted to legislation. But I think the answer is a little bit more complicated. The answer is a little bit more complicated because if it is straightforward repeal, Parliament will not object. It's a simple thing. But that draft has to come from somewhere. Who is it who is producing this draft? Now you're forcing me to say something that I deliberately did not say earlier. We keep talking about reforms, but reforms don't happen in a vacuum. They originate with a certain ministry or a certain department. All the reforms you will be able to think of have originated since 1991 with one of the economic ministries. So the answer to your question really is that the law ministry since 1991 has not been an agent for change. In my view, we have had only 2 good law ministers since 1991. Until yesterday. What happens from tomorrow, we don't know. But until yesterday, we have had only 2 good law ministers. Who are these 2? Now I'm sticking my neck out. As I said, your question forced me. One was Arun Jaitley. But what about the other one? The other one is actually not one, it is half plus half. The first one is Ramakant Khalap, who did not last long enough. And the second one was Virappa Moily, who also did not last long enough. So the right question to ask is, how do we get law ministry to become an agent for change and drive this? And this has to follow up comments which are equally important. The Law Commission is no longer what it used to be in the 1950s. The Law Commission, which often provides the initial trigger, has degenerated down the years. And the second point I want to make is it's not just the law minister and the law commission, it's also the nature of the bureaucracy in law ministry and also the nature of government council which leaves a lot to be desired.
Mr. Debroy, if I could just ask you one more question. Dated doesn't always mean outdated. So the Indian Contract Act was passed in 1872, yet it remains to be one of the least criticized bits of legislation in history. As you anecdotally mentioned, there are certain legislations which have been passed recently, but those have been open to criticism. The Arbitration and Conciliation Act doesn't define mediation, the Prevention of Corruption Act doesn't define corruption. Do you think in our zealousness to reform, we'd be jumping from the frying pan to the fire by having haphazard, half-baked laws coming out now, rather than leaving those which have worked fine so far? Is status quo sometimes a better option? Succinctly.
You see, you made a reference to the Arbitration and Conciliation Act. The Arbitration and Conciliation Act, unfortunately, it was diluted. This was not the original draft. It got diluted in the process. But all said and done, actually your question wasn't about the Arbitration Act. Nonetheless, the Arbitration Act, compared to the earlier Arbitration Act, I think it is still an improvement. I'm not saying it's a perfect thing, but it's still an improvement. But your broader point, I fully accept. And this is partly linked to my response to this gentleman's question, that quite often we enact legislation without taking stock of what already exists. So particularly any suggestion that says, for example, and I'm just picking an example, any suggestion which says, I want to amend section so-and-so of IPC, I am extremely worried, because that's not the way you reform. You reform by taking a whole new look at all of IPC. You do that and you're asking for trouble, which is, I guess, what you are also saying. But now that we are nearing the end, let me bring in two anecdotes from the Mahabharata. And I'm going to tell you something, not anecdotes, two factoids from the Mahabharata. And I'm going to tell you something that I'm reasonably certain you did not know. First, let me tell you something that you do know, which is that in the Mahabharata, there is a very, very extensive section, two sections, where Bhishma is instructing Yudhishthira on Raja Dharma. This you know. What you may not know is some of those teachings are richer than Kautilya's Arthashastra. However, the two factoids I want to give you, there is a listing of the most important disputes, civil disputes first, of the most important disputes in order of priority that would surface before the king, and the king ought to address those 17 kind of disputes in that order of priority. In this listing of 17, so many thousands of years ago, guess what was number one? Civil, I said. Guess. Breach of contract. Also in those sections you will find the following assertion. If it is a rich person, I should never imprison that rich person. If I imprison that rich person, the cost of that imprisonment is being borne by the public exchequer and therefore by society at large. So for a rich person, it should be a monetary penalty. Imprisonment should be for a poor person who cannot afford to pay a monetary penalty. Had I not given you the preface that this is from the Mahabharata, you would probably have said, this is something that Ronald Coase must have written. But it figures there in the Mahabharata.
Hello. I have two questions. One of the, in the mail it was mentioned that Reserve Bank of India Act is, Reserve Bank is a temporary institution.
Reserve Bank is a
temporary institution under Reserve Bank of India Act.
I didn't say that. The Reserve Bank of India acts as that. Yeah.
So what can happen if something like police comes and says that, okay, this is a temporary institution and...
Hold the mic closer to...
Oh, it's a problem. No, what can happen because it was the law was before independence. So can the British government come again and say that it is a temporary institution and now we can close the and go with it?
No, look. Some pieces of legislation, old pieces of legislation, they are mildly amusing. That's not really the issue. For example, something that Mr. Modi has been talking about in his speeches quite a lot, that in Gujarat he discovered that police have a right to check the way you are flying kites. What he did not mention was the piece of legislation, and the piece of legislation is something called the Aircrafts Act of 1934, which gives the government the right not only to monitor aircraft but also balloons and kites. The more substantive question is on the RBI. RBI, we know, is not a truly independent central bank. Forget the economist's argument of monetary policy not being truly independent of fiscal policy. In the RBI Act itself, there are any number of instances, including the composition of the board, including the selection of the governor, where you do not have that independence. So per se, simply because the preface says that it's a temporary institution, that's not terribly important. Just as because the Aircraft Act says that all aircraft in India must be VT, registered VT, which is actually, well, it has a, let's not get into the details, it's a colonial legacy.
Yeah, one more question. In 1962, that the case of Meerut, a goldsmith gold was taken by the police, and police inspector stolen the gold in 1962. In that case, the case was given when he had claimed that he was a real goldsmith, and the next day the custody was not given of the gold because gold was stolen by the inspector. Then the case was run for 5-6 years, and on the condition precedent, the government has not given any compensation to that goldsmith. So, my question is, how can this thing will be changed? Because if government or police authority makes such mistake, and it was given on the basis of the condition precedent of 1860, that the kings cannot do any wrong.
I get the drift of the question. You're still not holding the mic close enough to your mouth. The specific instance does not matter. I think your question is, why don't I have, using the standard principles of law and tort, or law of tort, why cannot I claim liability from the government? Essentially, the answer is, as of today, there is no liability against the government. The law of tort does not apply. A piece of legislation which would have enabled liability against the government was drafted, I think, if I remember right, in the year 1967, but it never became a piece of law.
Good evening, Mr. Debroy. I have a quick question. Is there something called process of representing the government about the redundancy of the provisions of various laws which perhaps may be applicable, may not be applicable, or if they are applicable have no significant impact but only compliance sort of thing? So that was one question. Another question is, what was the outcome of the central law reform projects? If you can narrate briefly, would help us to understand what has happened, at what stage we are. Thank you.
You see, the process is what? The process, assuming it is the central government, You just provide inputs as a citizen. I'm saying you provide inputs to Sucheta and Devashish, so they write about it, etc., etc. And actually that response is not very different from your second question. This is a question that people have often asked me, that what has been the outcome of this project called Large? This is a very difficult question to answer because it depends on how you are defining outcome, defining success. At one level, the outcome can be sensitizing people, disseminating that information, advocacy, persuading people that law reform is important. If you are talking about that, with hindsight, Large was phenomenally successful. The other kind of outcome indicator is, did it actually lead to legislative changes? This is a tougher one to answer because legislative changes themselves, they are part of a process. They are not instantaneous. They happen over a period of time. I earlier made a mention of the old laws that were scrapped when Arun Jaitley was the Commerce Minister. This was the Law Minister. This was 2000, 2001. The background to this was the year 1998. In the year 1998, the United Front government, yes, it was still the UF government, or maybe it was set up in 97, it must have been set up in 97, set up a commission on administrative law. And what is administrative law? Subordinate legislation, laws, rules, regulations, orders. This was known as the Jain Commission. I repeat, Commission to Study Administrative Law. This report, by the way, has disappeared. All law reform reports, they just disappear, vanish. Anyway, so if you find this report, it says, I'm paraphrasing a little bit, but it says, we are a commission set up to examine administrative law. But no one in this country has been able to tell us what the administrative law of the country is. So we are unable to do what we have been asked to do. Instead, we will recommend abolition of old laws. To recommend the abolition of old laws, the Jain Commission picked up the identification that had been done by Project Large. So eventually, somewhere down the line, out of the 1500 that Project Large and Jain Commission had identified, 200 got repealed. Then there were other instances where, let us say, the project recommended, actually you look very unhappy, but we were responsible for the original draft of the Arbitration Act. So we drafted legislation, Arbitration Act, Copyright Amendment Act, things that involve intellectual property, or things that involve changes that were being done either because of multilateral or bilateral or whatever trade commitments, or because we were opening up the infrastructure sector, they got done much more easily. Whereas whenever it came to something like the Essential Commodities Act, it would get stuck. So there was a huge continuum of spread, and it's very difficult to give a simple answer. Transplantation of Organs Act, that just happened. So the legislative thing, it varied enormously. He has had a question for some time.
Hello.
She also.
Yeah, so one question here.
So,
sir.
Shall I?
Can I continue? Yeah, so it is about, I think it is not about, there are two parts. One is flows in our laws, and other one is about execution of cases through judiciary. See, because we have seen that so many loopholes are there in our judicial system, and the main culprit is vested interest syndication, maybe vested interest by politicians, by some of the advocates or the criminals. Every common person knows that what are the problems, but this group of vested interests, they are not allowing this judicial system to work in a fast, efficient manner so that cases can be delivered fast-track, so that some conclusion can be come. Do you think that this vested interest, this group which is not allowing this reform, that can be break with this new government?
Well, I don't entirely agree with your distinction between the two, because the procedures are also dependent on the law, the procedural law, whether it is the Civil Procedure Code, whether it is the Criminal Procedure Code, whether it is the Indian Evidence Act. So unless you change provisions in those, I don't think you can speed up the judicial process. Where I also disagree with you is on the standard portrayal that the vested interests are politicians, judiciary and the bar. They are, but you must also appreciate what is sometimes not appreciated. The vested interest is also the litigant. The moment there is a civil case, once the facts have been established, I'm talking about a civil case, once the facts have been established, once the issues have been framed, anyone with any degree of sense will be able to give you a range of what the eventual outcome will be. That eventual outcome will not be preferred by one of the parties. So that party has a vested interest in protecting the status quo for as long as is possible. And this is especially true of property-related disputes. So yes, judges are to be blamed. Yes, judiciary is to be blamed. But please let us also recognize that litigants themselves are to be blamed.
Sir, I hope this question is not too flippant. It's like Mr. Arvind Kejriwal's refusal to pay the bail. Does it set a case for legal reform, or do these laws pertaining to bail, do they fall much in line with what you stated in Mahabharat, like rich men should be charged with penalty, whereas poor people could be imprisoned?
I think what Mr. Kejriwal's case establishes is one, it establishes a case for greater legal literacy amongst all citizens. The second thing which it establishes, except the media is not portraying it exactly like that, is a rephrasing of what I said earlier, that there are many so-called crimes where we need to examine whether these should be crimes or whether they should be subjected to civil action. And this includes defamation.
Quick question. We had a great discussion about all the different challenges. Just wanted to find out if you look at countries like US or UK or France or some of the other established democracies, can you talk briefly about examples where these problems have been addressed more systematically, or they have a regular process of, every few months or years look at all old laws and redo them or refix them, or how do they go about it?
I hate to use this expression because the differences are blurring, but there's a civil law system and there's a common law system. In many civil law jurisdictions, not all, many civil law jurisdictions, a statute is enacted for a limited period of time. at the end of that limited period of time, unless a fresh review establishes the need for a continuation of that statute dies a natural death. This, again, because of historical reasons, is not a principle that is necessarily followed in common law jurisdictions. But yes, now that everything is becoming codified, what essentially is the difference between civil law and criminal law, and civil law and common law? If you leave out the personal law and the inheritance law, everything else is getting codified. So for everything else, I think there is a strong case for implementing this principle, which is that this statute is enacted for 25 years, after that it dies a natural death.
Okay, last question from me. You mentioned that the state laws are a major issue and it's a black hole. Nobody even knows how many state laws are there. On many other things, even within the federal structure, last 10-15 years, there has been an idea to incentivize the state. So if you repeal this or if you reform that, and then we'll tie up the aid or transfer or grants to you. Was something like this thought about for laws? One law I can remember is the Rent Act, for instance, on which that kind of an incentive was tied up. Was something thought about on a broader level, all laws put together, and if not, what could be done?
The way you've asked the question, the answer is no. The only such attempt, I'm not very sure one should use the word incentivization, I guess it was in some sense incentivization, was not on changing the statutes, but on the speed of dispute resolution. And there what was done was, money was given to states for fast-track courts. It began originally with the 11th Finance Commission, but then it continued up to the 13th Finance Commission. But the trouble was, when this money was given, it's not really a state government. It is really what the state high court decides to do with that money. And some states have used that money quite well. The others have not. But the more direct answer to your question is, outside dispute resolution, no.
Thank you very much, Dr. Debroy. This has been a wonderful, wonderful evening and a huge learning experience. I think we should all give him a big hand. Thanks for Moneylife.